Hey guys, and welcome to today's video. Today, we have a follow-up to a sovereign citizen named Nicholas McKinney that I've covered before. In his last appearance, he insisted on representing himself because a real lawyer wouldn't understand the actual rights guaranteed by the Constitution to a living man. Well, that decision backfired on him, and now he's suffering from a condition known as instant regretalitis. So let's begin.
Okay, this is 23 CR 5137, People versus Nicholas McKinney.
Holly Sneed and Rebecca Casterline for the people.
Okay, good morning.
Morning.
Nicholas McKinney, pro se.
And Ashley Woodham as advisory counsel for Mr. McKinney.
Okay, good morning, everyone. We are set for appearance on arrest warrant after failure to appear by Mr. McKinney on Monday. Is that accurate?
Yes, Your Honor.
Okay, how do we want to proceed on the failure to appear?
I'm asking the court to quash the warrant. We're here now for appearing before the court, and I'm hoping that the judge will understand that there was a scheduling error that was made by me and my wife, and that I got in touch with the court so that we could reschedule this hearing so that we could appear before you.
What's the people's position?
I will defer to the court, Your Honor, considering that they are here today.
Yes, but do you have a position?
I don't.
Okay, based on that, Mr. McKinney, I will quash the warrant. I don't think I ordered a forfeiture, but if I did, I'll vacate the forfeiture. Reinstate your PR bond that you were previously on. Thank you for taking care of that timely.
Thank you, Your Honor.
Okay, the date that you failed to appear for, we were set for a status conference. I wanted to make a brief record before the parties address anything. I had issued an order denying motion in order to issue subpoenas on June 30th. At the time that I issued that order, I think I say in there that there was a request for 16 subpoenas to issue, and that at the time there had been only something like 11 affidavits filed. When I was re-reviewing the case, I think for Monday, I saw that there were additional subpoena affidavits that are present in the record. I think what happened is at the time that I drafted the order, they just not had made it into the court record, but apparently they were filed in the clerk's office. So I'm just making a correction to my written order. All of the subpoenas requested had attendant subpoena affidavits that were filed, but it doesn't change my analysis. The same deficiencies are noted even with the additional affidavits. So I just wanted to clarify my written order. Anything additional on that by the people?
No.
Anything additional on that, Mr. McKinney?
Yes, Your Honor.
Okay.
I've had the chance to speak with Ms. Whittam, and I have a better understanding of the requirements for filing the subpoenas. I believe the subpoenas are vital to my case. There's evidence that I would be presenting that the witnesses I would need to question the witnesses, and without them, that would detrimentally impact my ability to represent myself and prevent me from having my constitutional rights and my due process. And so I'm asking the court if I can get the court to do a continuance so that I can file that paperwork with the court correctly for those witnesses to be present.
Okay, it's a related issue, but you didn't have any other record you wanted to make on my order, is that correct?
No, no,
Okay,
Your Honor.
So turning to your issue, it's really what you're requesting is, in light of the denial, you're requesting to continue the jury trial.
Yes, Your Honor. I would like to be able to file this paperwork with the courts correctly. And I also believe that Ms. Whittam's trial's going to continue out till about Tuesday. And so she wouldn't be present for the first day of court. And so I'm hoping that the court would see that there's a little bit of issue at the beginning of trial and be willing to allow me to file that paperwork. It would be filed today. I would go directly down to the clerk of courts, file that paperwork correctly with the courts, pay the fees, pay all the travel and all of that stuff so that there wouldn't be any further discrepancies.
I can make a brief record on that, just about my availability.
Okay.
I'm in trial in Arapahoe County and it was supposed to finish yesterday. We did not get through the trial, and so we are ordered back on Monday. I do believe our trial will finish on Monday. I did reach out to Ms. Sneed and Mr. McKinney yesterday as soon as I realized that. I think Ms. Sneed and I had talked about potentially starting this trial on Tuesday. I did also talk to Mr. McKinney, and if the court is denying the request, I think everybody's in agreement to start the trial on Tuesday if that would work for the court. But I did want to make that record. That is unfortunately kind of outside of my hands at this point. I can't be two places at once and had a trial that didn't finish timely. So
Mr. McKinney, is it accurate that, we could potentially start the trial on Tuesday?
I feel like without the witnesses, I couldn't properly represent myself or defend myself in the courtroom. And so I'm gracefully asking the court to consider the continuance. It doesn't have to be very far out, just enough time for me to be allowed to file those motions correctly, pay the fees, have the subpoenas filed, and pay the travel fees and everything so that those subpoenas can be delivered. Those witnesses can be subpoenaed for trial, and at that stage, I would be prepared to go to court.
Unfortunately for you, when you decided to go pro se, you agreed to be treated like any other lawyer would be treated. And if a real lawyer came to the court with these requests for these reasons, the judge would say no. In fact, I have a set of videos from a sovereign citizen who won his case because the prosecution couldn't get the lab results on his confiscated drugs in time for his speedy trial rights.
So I know we talked about this a little bit, Mr. McKinney. My concern is that you had the obligation to know these rules of procedure when you decided to go pro se. And as we discussed on the last court date, my understanding is you waited to the last minute and then asserted that you weren't ready. And then I gave you an opportunity to then comply with Rule 17. You did file the motions, but they were woefully inadequate. This despite the fact that when you decided to go pro se, the expectation was that you would know these rules and comply timely, and notwithstanding the fact that that was the expectation and your obligation, I had also, as the people reminded me, on a prior hearing date, advised you to refer to Rule 17 for subpoenas, and notwithstanding that additional advisement, you again didn't take any action until I think it was our pretrial conference. And then you asserted that you were going to start doing that.
Your Honor, part of the reason that I asked for advisory counsel is because I had public defender and requested the public defender to take these actions in which Mrs. Julie Hutchinson refused to file on any of that on my behalf.
Hold on, sir. Attorneys are in a different position. Attorneys don't have to go through the process of filing a motion. So to the extent that you relied on an attorney for something in a prior proceeding, it's simply not going to be relevant. And the fact is, and what the starting point here is, you had ADC appointed. That's what the court record reflects. You had Ms. Whittam appointed as alternate defense counsel. You chose to represent yourself, understanding the obligations and risks. So whether or not a prior attorney was going to subpoena people or not is really completely irrelevant at this point. So I don't want to go backwards.
Okay, Your Honor, I understand that. And I have been attempted continuously with Miss Whitten and with the courts to make sure that, and with the clerk of courts, to make sure that the paperwork that I'm filing with them is correct with the courts. I spent a very long time down there with the clerk of courts, talking to the clerk of court to make sure that the paperwork that they were receiving was adequate for the court. The clerk of court told me, yes, this looks good. I understand that my subpoenas are lacking. I've talked with Ms. Whittam to further understand that. I now have the understanding of where my subpoenas are lacking. I would cordially ask Your Honor for a continuance so that I can summons those witnesses. They are crucial to my evidence and my defense.
So I want to be very clear. The clerk of court, or the people that work in the clerk's office, cannot give legal advice. And so to the extent that you're asserting that you were relying on them for any sort of determination on whether you did something correctly, that's not appropriate. They may have said, it looks fine in that the case caption is listed, the case number is correct, you've signed the pleading, but I know for a fact that they do not give legal advice. You cannot rely on the clerk's office to tell you whether something is accurate or sufficient. That's your responsibility when you choose to proceed pro se. My question for you, sir, is why did you wait till the eve of trial to begin this process when you've been representing yourself for months and when I had previously advised you to go to Rule 17 well in advance of trial if you wanted subpoenas?
Your Honor, I read Title 17. I believed that I was filing the paperwork with the court correctly. I even asked for the clerk of court to verify. I wasn't asking the clerk of court to hold my hand through the process. I had read Title 17. I filed all of the paperwork. You yourself stated that they were all filed with both pieces of the paperwork there. Just the statement as to why the witnesses were required was insufficient with Title 17.
It's not Title 17, you moron. It's Rule 17, which is the Colorado Rule of Criminal Procedure that governs subpoenas. You might want to know the difference between titles and rules if you're going to be representing yourself.
That's not what my order said. I didn't say anything was done sufficiently or correctly. I was clarifying because I had misnumbered the number of subpoena affidavits.
And that's what I'm saying, Your
Okay.
Honor.
And I know it might sound particular. We're not talking about Title 17. We're talking about Rule 17, which is
Yes.
the process for requesting subpoenas.
And
Again, sir, my question for you is, given that it's the timing of your attempts to start this process that is giving me pause and concern.
I have been trying to do this process the entire time. I have not been disregarding the importance of this case. I have not been ignoring this case. This case has been ongoing for 3 years, and I have appeared continuously and done my best to appease the court at every turn. I am fundamentally trying my best, Your Honor, to stay in alignment with the rules and in alignment with the court. And I understand the monumental importance of this case. And so I am trying to do my best to be an American and stay in line with the Constitution and the rules and with the court and with the proceedings and be timely and be cordial and appropriate in court and just explain my position, Your Honor.
I want to focus on the issue that we're talking about, which is your readiness for trial. And the impediment you're articulating is that you have not subpoenaed witnesses.
Yes, Your Honor.
So I don't want to talk about general things. I want to talk about the fact that when we set the trial, you had a trial date. That would have been the time to begin the process to subpoena witnesses. That trial date had been set for months. You didn't make any motion for a subpoena until June 29th for a trial to begin July 13th.
Your Honor, as you're aware, there was a previous judge in this case. I made motions with that judge so that I could reclaim time and be prepared for this. I attempted with the court to do those things. Now, no, maybe I did not file a motion for witnesses at that time with the previous judge, but that's part of the reason why I made a motion with him to reclaim time. This case continued for a long period of time with a public defender that was unwilling to do those things for me. I made the previous judge aware of that. I tried to reclaim time so that I had time to do those things so that I could file the appropriate paperwork. I could file the motions. I could file the subpoenas that were needed. Instead, the previous judge recused himself, and now we've jumped into, okay, you're pro se, we're speeding to trial. I didn't get to reclaim time. I didn't get to do any of that. All of the motions that I did file have been denied. All of them have been denied. I've asked the court multiple times what my insufficiencies in my paperwork are. I've asked for clarity. I've read multiple caseload and case law. I've looked at Title 17. I've
Mr. McKinney.
pursued all of
Mr.
this.
McKinney.
You should have pursued a lawyer who can help you out with your mental deficiencies and lack of legal training, but you thought you could do it on your own, and now you're regretting that decision, aren't you?
Please listen to what I'm asking. Okay, I'm not going backwards to prior judges, prior attorneys, reclaiming of time. This case came to me on March 16 of this year. There was a request by the people to continue the trial that was set to begin that day. You didn't object. Speedy was waived, I believe, at that time, and then we reset Speedy as September 14. That's a speedy trial deadline. That same date, we set this jury trial to begin July 13. What did you do from March 16 to make sure that you are going to be ready for trial with respect to subpoenas since then?
I've filed subpoenas with the court.
When?
I don't have the dates with
Are you
me.
talking about the June 30th?
I've filed subpoenas with the court.
The June 30th filing, the June 29th filing, motion and order to issue subpoena. Is that it?
I've filed many subpoenas with the court.
Tell me where in the court record those are located.
I don't have the court record, Your Honor.
Okay, I'm going to make a finding that you haven't, because there's nothing in the court record until June 29, when you filed the motion in order to issue a subpoena. So what did you do between March 16 and June 29 to attempt to get subpoenas ordered, issued, and served?
I could show you on my phone, Your Honor.
Why don't you
I-
just tell me?
I tried to be in contact with Miss Whittem many times to pursue further clarity from the clarity that you provided me to make sure that the motions and the subpoenas that I was filing with the court were accurate to the rules so that there wouldn't be any of this unnecessary back and forth with the courts. I tried to get Miss Whittem multiple times and her office to schedule with me so that I could pursue further clarity, make sure that I was filing the paperwork correctly with the court. I also have been in and asked you for clarity. I have read all of the caseload laws that I believe apply to this. Like I previously stated, I am not an attorney. I'm just the live living man. I have been put in a position by my previous public defender to have to,
I'm not going back. You
To have-
had ADC counsel. It is totally irrelevant what your prior public defender did. You had ADC counsel at the time that you made the decision to go pro se. So I'm going to ask you to stop going back because it's totally irrelevant. What I'm hearing you say, sir, is that you didn't take any action because your advisory council was not available to meet with you despite your requests.
no, Your Honor.
Okay, then
That's-
tell me what you did between March 16, when we set the jury trial date, and June 29th, when you finally filed the motion.
I have continuously been on the computer reading case law, reading the Constitution, reading the rules so that I could better inform myself to represent myself. I have pursued my advisory counsel so that I could present the proper paperwork filed in the correct form with the court so that we wouldn't have to do this back and forth. The paperwork would have been filed correctly. Ms. Whittem was unavailable. We all know she was in trial. That prevented me from being able to have clarity as to what my discrepancy with the court was on that paperwork. I've read all of the Title 17. I believed that I was filing that paperwork correctly with the
Mr.
court.
McKinney, I'm talking about before. What did you do before June 26th?
The same thing. I filed paperwork with this court.
There are no requests for subpoenas before that date.
No, I understand that, Your Honor.
So what did you do to prepare to get those subpoenas requested
I was
before?
unaware that I even needed to file those subpoenas until the court made me aware that I had to file them in a particular way. I've been advised multiple times by different people that that's not how it works.
Mr. McKinney, frankly, I have concerns about your ability to represent yourself because what you keep telling me is that you don't understand the court and you're waiting on the court to give clarity. You're waiting on other people to tell you that you've done it right. You're checking with clerk's office. You seem to be implying that you don't have the ability to follow the rules of procedure and to otherwise prepare timely. Am I hearing you correctly?
Your Honor, I did file for a public defender in the beginning, did I not?
I'm talking about the subpoenas. Why do you keep talking about these other matters?
You just asked me a question of whether I was prepared to defend myself or not.
No, I said to represent yourself at trial.
Yeah,
Because you keep telling me that you're relying on a bunch of other people who owe you no obligation, who are not the appropriate people to be advising you, yet you keep relying on them and making critical errors. Why are you doing that?
Because he's an idiot. That's why. You could also blame the sovereign citizen guru or website where he absorbed this bad information, or maybe even blame the lack of a bullshit filter in his brain.
I've informed the court that I have read all of the case laws and stuff I believed was pertinent, that I tried to file the paperwork per what I believed was accurate to the law and the court's requirements.
And you were wrong. And that's why I denied the motions. And when I'm asking you why you waited until June 26th to even begin that process, despite taking on the obligation to know those procedures, despite my having advised you previously to look at Rule 17, you waited until June 26th to file the request for subpoenas. That's the determination I'm trying to make, is why did you do that?
Your Honor, there isn't just those subpoenas when you represent yourself. There's pretrial statements, there's lots of things.
There are lots of things, but you're asking to continue the trial because of the subpoenas. You haven't articulated any other reason why you're asking to continue the trial. So as it relates to your request to continue the trial, you're saying you cannot be effective because you don't have subpoenas either issued or served, right?
I cannot represent myself effectively because those witnesses are vital to my defense and to the exhibits and the videos and the statements that I have and intend to present.
Okay, so if they are so vital, why did you wait until June 29th to request subpoenas issue?
I told you,
You haven't told me. That's why I keep trying to ask it in different ways.
I tried to file things with the court. All of them have been denied.
I'm not talking about things with the court.
Subpoenas,
Request
motions,
a motion
requests.
for subpoena. When was that filed in the clerk's
I-
office?
Don't have those dates with me, Your
Okay,
Honor.
I'm making a finding that you're wrong, that you haven't. Those would be in the court record. And just like my order on your most recent filing, the motion that was filed, I would have issued an order denying if in fact you had filed this very motion similarly. There is nothing in the court record to indicate that you filed a motion or request for a subpoena. We had a prior discussion because you attempted to come to the courtroom office window to file things which you asserted were evidence. Those were rejected. One, because you don't file things with the courtroom window. Two, evidence is not admitted by filing. It's done in hearings, which I've previously explained. So I don't believe you're being honest with me, frankly. You have not filed any requests for subpoenas that I can see in the court record. Am I missing something? Are the people aware of any filing indicating there's a request for subpoenas that I'm missing?
No. There were other motions filed, but there has never been a request for subpoenas before June 29th.
Your Honor, June 29th is when I filed them.
Yes.
Now, We all know that and understand that. I was unaware of that until that period of time that you advised me, and I promptly filed that paperwork.
You were aware of it when I advised you to comply with Rule 17 at the prior hearing.
And
And you should have been aware of it at the time that you decided to go pro se.
I was not.
That's the
And-
problem, sir.
And I already made it apparent to the courts that the reason that I went pro se was because I was under duress, because I was not being adequately represented by my previous public defender. There was only one option as to getting the evidence on the record, which was for me to go pro se and attempt to get that evidence on the record myself.
It's not duress, it's duress. Just like it's not soft tart, it's soft hard. And how exactly were you under duress when no one was holding a gun to your head, nor was anyone forcing you to go pro se? That was a voluntary choice that you made because your original lawyer valued their law license more than they valued your pseudo-legal get out of jail free gibberish.
Are you saying you went pro se under duress now?
Yes, Your Honor.
Well, I'm not going to accept your decision to go pro se, and I'll reappoint counsel then. If that was an advisement or a decision that you made under duress, I'll reappoint counsel.
Okay, Your Honor.
And I'll make a finding that you don't have the ability to go pro se, and that was not a knowing, voluntary, and intelligent decision.
Okay, Your Honor.
What's the people's position on everything? A request to continue, the Arguello advisement that was previously provided?
You know, certainly, Your Honor, the people are ready. We have several medical witnesses that are holding off their patients for next week so that they can testify. I understand the court's ruling, especially with Mr. McKinney's statements now that he was under duress. I think that unfortunately calls into question the Arguello advisement that he previously did. The people are still ready. The people are still asking to proceed next week, even if that means starting on Tuesday, if that's possible. So that is the people's request.
Mr. McKinney, do you understand that if I make a finding that your prior request to go pro se was under duress and therefore invalid, and based on my conversations with you here today, I would likely find that you're not able to proceed pro se, despite assurances previously that you were able, that if I reappoint counsel, I am highly, highly unlikely to, if you request to go pro se at a later date, to grant that request based on the entirety of the record, and you will be represented by counsel. Do you understand that?
Yes, Your Honor.
Ms. Whittam, you were ADC counsel, I believe, at the time. Is that correct?
I was, and it didn't happen out of a burger root hearing, so I would be available to re-accept appointment if the court wants to accept. With that record, I am not ready for trial. Obviously, my role as advisory counsel would be different than trial counsel. And so I think the other thing I would, if the court is wanting to appoint me, is to make sure before I'm appointed that the court advises Mr. McKinney of his right to a speedy trial and that it would need to be waived in order to have me reappointed back on the case.
I will do that. Let me just say this, Mr. McKinney, I mean, frankly, you're asking to continue, which would require a waiver. And obviously, if I reappointed counsel, your counsel understandably would not be ready for a trial to begin next week. Based on that, are you willing to waive speedy trial?
Yes, Your Honor.
Okay. I would make a finding in the alternative that it is a request on behalf of defense, the defendant to continue the trial and would require a waiver, and I would attribute a waiver. But I'll make a finding that Mr. McKinney, understanding it's his request, is making a knowing, voluntary, and intelligent decision to waive speedy trial. The people, I understand, and if you didn't explicitly state it, an objection to request to continue, I certainly understand. given the circumstances before me, I'm going to grant a continuance of the jury trial. I am going to make a finding that, as Mr. McKinney asserted, that decision to go pro se was not valid, an allegation of duress, and certainly based on the things that have happened since we set the trial date in this case, I'm not sure Mr. McKinney has the ability to proceed pro se for whatever reason, despite what he asserts are significant efforts to be able to comply with the rules and the applicable law. He's been unable to do it. So I am going to reappoint counsel. Ms. Whittam, will you accept appointment?
Yes.
Thank you. You are reappointed as counsel of record. Speedy trial is waived. New speedy trial I will set as January 8 of 2027. The jury trial for next week is vacated. Do we want to try and set trial now, or do you want to set it for a status to check on witness?
So I was just speaking to the people. I think what we would like to do is set for a status. I just was speaking to Mr. McKinney. He's willing to toll speedy between now and when we come back for a status.
Okay. What's the people's position?
I think that makes sense, so that we can reach out to our witnesses and ensure we have everyone's bad dates so that the next time this is set, it is a go.
Okay. All right. Mr. McKinney, I want to confirm on the record with you. You've spoken with your now counsel of record. Tolling speedy trial means that the speedy trial clock, or that time period, although I've set speedy trial as January 8th, the time between now and when we set that next court date will not count, and it will extend that speedy trial deadline. We'll reset it based on that tolling the next time we address speedy. Is that your understanding?
Yes, Your Honor.
Are you making that decision knowing, voluntarily, and intelligently?
Yes, Your Honor.
Is anyone forcing you to toll speedy?
No, Your Honor.
All right, court accepts the tolling of speedy. When do we want to set status?
I don't know if the people can come back on July 24th. If that's, oh, I see that's blocked out on the court.
Yeah. My preference would be for a Monday for if we're just status, but
Back on August 10th.
I can do
Yeah,
that.
Monty has this ABA stuff, but what I'll do is we'll just schedule it and I'll just cancel the ABA that day so that we don't have to do the scheduling back and forth.
August 10th works for the people as well.
Yeah, this works for me as well.
August 10.
Yes, please.
Okay, we're going to reset this matter for status August 10 at 8:30 in this courtroom. Speedy's tolling at least until that date, and we'll readdress it then. I normally, on a case like this, I would try and give the parties potential jury trial dates. I'll say just because the calendar changes so frequently, it's difficult. But if the parties confer, when you have a better sense on availability, if you want to contact the courtroom
Okay.
ahead of time, we can at least give you a sense on what for sure won't work, or
Perfect.
but just know that probably makes more sense for you all to have a couple dates in your mind and then check with the court closer to that setting date. Just because, again, as everyone knows, the jury trials, whether they're going or not, on any given week just can change from week to week. So is there, I'm going to defer. I think we were also set to address the jury questionnaire today. I'm just going to defer that. Parties can work on that separately. And it sounds like something we can address at a later date, but just remind me at some point that that's an issue that's still outstanding.
And I'll confer with Ms. Sneed. I have that questionnaire, and so her and I can work and we just
Okay.
come to an agreement and get something filed with the court.
Okay. Was there anything else? Do we need to, I'm sure parties had other things to address anticipating trial, but based on where we are now, is there anything additional from the people?
I don't think so.
From defense?
No.
Okay, We'll see everyone August 10. Is that what I said?
Yes.
Okay.
Yes.
All right, bonds continued.
Thank you.
All right.
All right, so that's the end of today's video. A few things to note here. First, the court did remove his pro se status and reappointed a public defender to represent him. And second, by doing so, he will no longer be able to assert the sovereign citizen defenses, and there is an extremely likely chance that he will no longer be able to represent himself if his lawyer isn't doing his bidding. Basically, he screwed himself out of claiming that he's a living man and not subject to the jurisdiction of the court, while at the same time ensuring that the case moves forward and justice is served one way or another. I'd say that's a win-win for everyone involved, except for the soft tart. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and